my lords, my lady. I'll be as efficient as I can in my reply. So, first heading, I'll go straight in. First heading, overall shape of case. I mean, that heading kind of cuts across a couple of different points made by my learned friends about what wasn't argued below, what the complaint was and wasn't about, whether it was one of all of those points are all quite closely related. There was just a discussion, and I think it's referred to in the judgment, of my client having made a volte face, and my lord picked up, that's quite a strong phrase, it means 180 degrees. I don't accept that we've made, at any stage, a volte face, and I'll show you why that is, but probably the most important point, ultimately, is in my submission, we've ended up facing the direction we started in. Now, whether that's because we did 180, another 180, or as I prefer to say, we did 10 and then 10 back again, doesn't really matter, perhaps. But to make that point, simple point, good, and it also goes to this issue of what the actual complaint was about, can I ask you to look at, and I'm sorry we've looked at them before, but it's easy to make the point if you turn it up, a couple of references in the supplementary bundle. Tab 4, page 74. When you get there, this is the initial complaint that starts it all off. We've looked at it before. And in 2 paragraphs, the heart of the complaint is summarised. It even says, paragraph 3, the nub of the complaint concerns the fact that in course of concluding agreements, they've got the non-objection clause, they set it out, they say it's illegitimate, they say, and then 4, this clause has the effect of undermining the integrity of the planning process. Further, the object and effect of this clause is to substantially undermine the efforts of those opposing consents. So there, in a nutshell, is the complaint, and it's the argument that I make to you yesterday and today. The clauses are illegitimate, the non-objection clauses in particular are illegitimate, and if that's accepted, that had the consequence, therefore, of distorting the process. Obviously, that doesn't say the Secretary of State unlawfully failed to consider that, because we're before that stage, but that's the complaint. That's it. That's the whole of it. Same point, equally clear. Tab 11. Tab 11, page 164, over to 165. Again, we've seen it before. This is the 25th of March complaint. The 24th, I'm clear what the exact date is. SB 164, the complaint is very, very briefly summarised. Then on 165, I've shown it before. Under the heading on the previous page, evidence of the system used by SPR, etc. Critical bit on 165. The heads of terms contains a series of devastating restrictions, total prohibition on the landowner objecting to SPR's application, etc. So there's the complaint about the clause. And then critically, what the judge later calls the practical impact complaint, i.e. the consequence of that is that the process is undermined. Not that it's unfair to landowners, and certainly not at the heart of it, but the consequence for everyone else and for the integrity of the process is undermined. I've shown it to you already, but it's immediately under the next heading. Those 2 paragraphs. Effect profound, no landowners tenant given. This is meant that on a really wide range of important issues, prevent relevant going forward. That's it. It's the same point. It's the point we're making throughout. Obviously, we add to that now, and the Secretary of State failed to deal with it lawfully because it's all pulled out. Last iteration of it, my learned friends make quite a lot of this. Tab 19, which I didn't go to in detail in opening, but this is the submission sent to the Secretary of State after the close of the inquiry, and I mean, it's a bit more diffuse, I think I accept, but if you look in particular at paragraphs, so 345 to 347, paragraphs 10 through to 24, it's the same point. It's a complaint about the integrity of the process being affected by the non-objection clauses. Exactly the same point. That's the direction we started in. That's the direction I'm currently facing. Now, as to the question related to that, of whether this point was argued, just pausing there. There's a point that I don't, and I'm not just being forensic about it, fully understand that my learned friends make, which is that the complaint was or wasn't one of fairness at different stages. I'm about to say that seems to be about which chapter of Smith you put the judgment in, as it were. I mean, that, I've told you what the complaint is. I think that's probably fairly categorised as a procedural complaint. It's about the integrity of the procedure that was followed and whether it, as opposed to, if you like, the substance of the decision and the reasoning of the decision. I think it goes in chapter 9 of Smith, if that's the right chapter. But it doesn't matter. And it's not an issue, and even if, and I don't think we did, but even if at some points we described it as a point of procedure, and sometimes it doesn't matter. Again, related to that, remedy, it's right, and my learned friends make a lot of this, that my client's position was that the remedy which they should be given by the Secretary of State or the EXA was shut the whole thing out. You've seen the reference to that, I don't stand back from it. But the fact that we put our case at its highest, if you like, doesn't relieve the Secretary of State from the obligation of dealing with the complaint. I've made some suggestions yesterday as to other steps that can be taken. I don't resile from those suggestions. They seem to me to be legitimate. If I'm wrong about them, that's an unfortunate inflexibility in the system for consideration of these sorts of matters by the examining authority and or the Secretary of State. But I don't think there is that inflexibility. And certainly it would have been open to SPR in the face of a ruling from the Secretary of State, or I suppose an indication from the examining authority that they thought things had gone wrong, to do what I suggested yesterday. So on that basis, it looks like it might be remediable. Now, in saying that, I don't necessarily accept that on the facts of this case, doing it at any given stage would have remedied the problem, because it would be open to my clients to make the submission at that stage. Well, actually, it is too late. The thing's been too distorted. That would be a different case. But I don't think it can be right. There's nothing that can be done. The fact that my clients went so far as to say, actually, on the facts of this case, we've reached the stage where you can't do anything, doesn't take away the duty, doesn't undermine my argument, doesn't take away the duty to consider the complaint and deal with it. Then, my Lord, this point about what was argued below, which is also related to that, Mr. Philpott alights on paragraph 28 of the judgment, and I think he's probably right to do so. It's a CB 132. Tab 12, if that's helpful. Of this course. And the judge quotes paragraph 40 of the claimant's skeleton below, which we were taken to separately, but I don't need to go back. It is, of course, not the function of the court to rule upon the allegations and evidence as above that C put to the EXA and addressed to the Secretary of State. The court merely needs to proceed upon the basis that a serious complaint was made about the evidence collection process which the decision maker needed properly to investigate. So in other words, what Mr. Wolfe was saying below, Dr. Wolfe was saying below, seems to be, you don't even need to, it's not for the court to deal with whether there's a serious complaint, and in particular whether this is a serious complaint. And therefore I don't need, it's not the court doesn't need to decide the issue of the legality of the contracts. I think that is what he's saying. I suppose that is, if you like, a change of direction. It's certainly different from what I'm saying to you now. But the judge rejects it, as he says in paragraph 28, and I've not challenged his rejection of that submission, because not least because ultimately the complaint seems to turn on a legal issue, and it would be bizarre for the court to say, well, there's a legal issue here which the Secretary of State should consider for himself. I admit it, and then you can come back to me, it's mad. So I'm inclined to think the judge is right about that. It might be different if it was a purely factual complaint about, who said what to who and when and so forth. But in circumstances where it's effectively, the foundation of it is a legal complaint, we've accepted that the judge, we haven't challenged what the judge says in 28. But the logical consequence of that is the judge did need to deal with the legality of it, and our appeal, I'm not saying I necessarily conceived of this when I wrote the skeleton, our appeal is, when he went on to deal with it, on what he thought to be a concession as to legality, but which, as I've shown you from the permission, was merely a concession, he didn't need to determine it, he got it wrong. And that's the issue before you. And that, in my respectful submission, falls squarely within the grant of permission by Lord Justice Singh, tab 7 of this bundle, and it's CB 97, tab 7. And as the hearing's gone on, we've read progressively more of paragraph 2 of the grant of permission. I started with just the top bit. My learned friend read out some of the quoted bit. If you're on the page, there is a duty. stopped in the middle of the paragraph and I asked him to read on. I just think we need to read the final bit as well.
Yes.
So, but if we just pick it up slightly earlier, so in the middle of the paragraph that's quoted, that was read out before, that I asked Mr. Philpott to read, where a party, if you have that, where a party with a vested interest in the outcome of a decision makes secret payments to potentially important witnesses, prohibiting them from giving evidence and generally enabling that party to control and regulate the evidence that might otherwise be given, there is a powerful risk to the integrity of the decision-making process. And the skeleton continues, says Lord Justice Singh, rightly, when such conduct comes to the attention of decision makers, the public authority has a freestanding duty. Now, obviously, to resolve that issue, the court needs to consider what the conduct involved and what character it has. And that's the basis on which we now advance the case. Well, the conduct is problematic in the way that I've said. A matter was, I think I must accept, probably left unargued, but that's the issue squarely before you now. That's what I want to say about the shape of the case. It leads me into the next topic, which is the Tameside issue. In a sense, it arrives directly out of that. Because, as I've said, the point of principle which I am inviting you to look at is whether there has indeed been a problem to the threat. The contracts create a threat to the integrity of the process. In other words, are the contracts legitimate? If the contracts are legitimate, my learned friends are right. It's a Tameside case. Because if the contracts are legitimate, if I'm wrong on my main point, then the position is the Secretary of State, there's nothing has gone wrong with the process, but the Secretary of State presumably is entitled in the exercise of his discretion to say, well, I still note that the contracts could have restricted the evidence, albeit legitimately so. I think I'd like some more information, please. That's a classic Tameside case. And I can see I'm going to have difficulties in persuading it's irrational in those circumstances not to seek more evidence for all the reasons we've discussed. But if I'm right, but the contracts are illegitimate, then you're in a very different situation, which I don't think, well, I submit Tameside doesn't apply to at all, or if it does apply, it's in such an unusual way that it's not a very helpful way of analysing the problem.
What is it?
Well, my lady, if it, the question I was asked, and Mr. Philpott picked up on this, the classic approach of a court to where something has gone wrong in the procedure is to ask whether there's a real risk of prejudice, a real risk of harm to the process. So if there's some other unfairness, a court will generally quash the decision on the basis that it's an illegality, unless satisfied it wouldn't have affected the outcome, there's no prejudice. It's the same here.
That's the classic example of procedural unfairness.
Yes.
Your case is not being pushed.
Well, this is why, my lady, this is why I say it doesn't really matter whether it's procedural unfairness or...
Let's assume it's substantive unfairness, because
Well, then, well, my lady, then there is a complaint,
yeah.
which, if it's a legitimate complaint in the way that I've said, is a complaint about the... is a complaint on any view has a legal duty to deal with. He's got to deal with it. And one would look at it in a Wednesbury sense. That's my alternative.
Right.
But in my submission, it is ultimately in this sense, it's if there's a problem to the integrity of the process, it's no different from any other procedural complaint. That something has gone wrong in the process, which has led to a situation where the outcome may have been affected by that. Something unlawful has happened in the process, which has led to a situation. That is, in my submission, a procedural situation. My learned friends therefore say I don't cite any evidence, but if I'm right in, don't cite any authority, I don't know if this specific issue is dealt with in any authority. But if I'm right to categorise it ultimately as a procedural error, then it's a real risk test. If I'm wrong, it's Wednesbury. And you have my submissions on effectively both, so I don't need to revisit them for most purposes. I'm going to go briefly back to the decision in a moment. Third topic, I was asked yesterday about do I challenge the facts in the court below? And I freely confess I found it slightly difficult to answer that question. Partly, I think, because it is obvious that the case was argued somewhat differently. Let's be called a spade, it was. Partly because I don't find it that easy to know whether any particular thing said by the judge is correctly characterised as a fact. I don't think there's anything that could be characterised as a finding of primary fact. But in any event, for the purpose of just making the key points, can I just give you a couple of references in the judgment and say what I said about them? They're all submissions I think I've made, effectively. But it's helpful, I think, to put it in this context of my challenge of facts. So first of all, and you have this point already, but it's a good example, paragraph 191 of the judgment. Sorry, CB 171. This is where, if you remember, where the judge, having identified his, inverted commas, practical impact factor, says, C's complaint alleged unfairness, not the practical impact factor. Well, sorry, if that's a finding of fact, and perhaps it is a finding of fact, it's just flat wrong. And even if it's if the test is Wednesbury, it's wrong. On the contrary, as I showed you right at the outset of my reply, and also showed you in opening, is exactly the heart of the complaint that we're making was a practical impact complaint. The illegality in the contracts has distorted the process by preventing witnesses from coming forwards who might otherwise have done so. That's the heart of our complaint. Always has been. So if that's a finding of fact 191, the judge is wrong.
If on the fact findings there is no evidence that it prevented anybody from coming forward, aren't you in some difficulty?
So, sorry, Melody, I didn't catch that. No.
If the evidential position is that there is no evidence at all that anyone was actually inhibited from coming forward, aren't you in some difficulty in making
Sorry,
that
but be clear what the finding of fact in 191 is. The finding of fact, if there's a finding of fact at all, is that C's didn't complain about the practical impact. And I'm saying that is wrong. It is factually incorrect to say that C's didn't complain about the practical impact.
Leave that to one side. Point is, you're saying you're entitled to run an argument that the practical impact is to prevent people coming forward, therefore there's a substantive unfairness. I'm pointing out to you that on the basis of the evidence and the judge's fact findings, there's not a shred of evidence that anybody was actually inhibited from coming forward at all.
Well, that is an issue which should have been looked at first by the Secretary of State, in my submission. And our point is, and I'm going to come on to this shortly, but you've had my submission for it. I wasn't looked at by the Secretary of State. And indeed, I'm going to come in just a moment to where the Secretary of State seems to accept the opposite. So that's 191. That's an example of a factual. I'm just making a point about factual findings. A factual finding which is wrong here, is what the judge says there. And in fact, it's very striking if you read on with what the judge said, because 193, he makes a factual finding, if you like, that I say is correct and I rely on. Because at 193, he says this: because C's did not raise his fallback argument in the examination. Now, I say that bit's wrong, but because of that, he says, it is unsurprising there was no separate finding by the panel or the Secretary of State on the matter, the practical impact. Now, he's right. There was no separate finding by the Secretary of State on the practical impact issue. He's wrong to say that that's explained by it not being raised. And that actually rather starkly shows the problem in the decision making, in the decision. Shows why the Secretary of State's decision was, if I need to say so, Wednesbury unreasonable. So that's 191 and 193. Come back please to 139. Sorry, I'm going backwards. CB 160. The judge says this.
Paragraph.
Sorry, 139.
139, yeah.
The judge says this. I'm picking up all sorts of ancillary findings perhaps, but trying to focus on what matters. 139. In my judgment, the Secretary of State's unchallenged conclusion there had been no interference with the right of any affected person to have a fair hearing involved the rejection of C's allegations that those landowners had been stifled or neutralised, etc. Now, I don't know if that's a finding of fact or not, but if it's a finding of fact, yeah, I challenge it. It's wrong. It doesn't follow. It just doesn't follow. They're two different matters, as indeed I think my learned friend said. And as really is what the judge is saying in 193. Last one, 132, paragraph 132, page 158. So the judge sets out at paragraph 132 the passage I showed you from the second ministerial submission, if you remember, and the reference for that in the bundle, if you wanted in the original, is tab 23, 388. But anyway, let's just see what the phrase, the section in there that I focused on, as was done below, is the sentence starting, officials have considered these points, and the applicant's response to them, and then critically, we consider that although some landowners may have felt constrained from taking part in the examination due to agreements entered into with the applicant, and I submit to you that's officials at least apparently accepting. They're obviously not accepting my point of principle, so the significance of this for them, but that's officials apparently accepting that the effect of the agreements may well have been to inhibit people from coming forwards. Certainly the real risk, to use my phrase. And that very submission was made to the judge. And he says at 135, so the submission is summarised at 134, I think it's the same as one I'm making to you. It says at 135, those conditions involve a plain misreading of the ministerial submission, and then he talks about his point about procedural fairness and all the rest of it. But with respect, it's not a misreading of the ministerial. If that's a finding of fact, I don't know if it is really a finding of fact. It's about how you characterise what the ministers were being advised by the officials. Is that a question of, certainly not a question of primary fact. Anyway, however you characterise it, he's wrong. He's flat wrong, because it's perfectly clear what officials are saying, and it's a submission I've made to you already. And again, I noted, I mean, I'm saying they're bound by it, but I don't think my learned friends came back to you on that. And actually, that's quite striking, because if you think about that point, and now moving away from factual findings in the judgment, and think it's how it sits with the point I made to you about Tameside, officials are, of course, not proceeding on the basis that the contracts have been demonstrated to be unlawful. They don't resolve that question. So they are, in a sense, in a Tameside world. And in a Tameside world, there's no harm to the integrity of the process. You might well make the observation that a few people might not have come forward, but there's nothing illegitimate that caused it, and therefore no reason to take it any further. You've got a discretion about whether you want to go back to them or not. But that's why that observation, though not apparent to them on the basis they decided it, becomes very significant. That is, in effect, officials saying, answering the second bit of the question, is there a real risk of harm to the integrity of the process? You know, put it like this, obviously I don't want to overstate it, but in substance, yes, there is, because some people might not have come forward because of the contracts. So as long as I'm right, which they don't decide, contracts are problematic, yes, there's a real risk of harm to the process. And that brings me on to just briefly to the critical paragraph in the decision itself. And sorry, 523 of the bundle. So should say core bundle, that is.
Core bundle page.
523 tab 30. You've seen it lots of times, so it's paragraph 26.32, and the only bit that really matters is that final sentence. Having also reviewed the totality of the Ex's report, the Secretary of State considers that all relevant issues were raised and explored in the examination, and that he has the necessary information to enable him to make a decision. Again, if we're in a Tameside situation, if there's no harm to the integrity of the process, that's fine. He's satisfied, he's got enough information, he's got a discretion to ask for more information, but he's decided not to do so, no problem. But if the process has gone wrong, been made, as to pick up a phrase that was used in argument yesterday, been made less perfect than it should have been, not it could have been, because that's an impossible aim, but that it should have been, then that's not good enough, because it's missing the point that some evidence which should have come forward, or which might have been able to come forward legitimately and was illegitimately prevented, did not come forward. And you're back into real risk, Wensbury. And whether it's real risk or Wensbury, it doesn't deal with it. My Lord, I want to make a few very, very brief points about the very wide-ranging factual points my own friends made, and I'll take it really very quickly, and I just want to come back to the point of principle. factual points then. Can we just turn up the examining authority's report? That is page I want is 602 first of all. No, sorry, that's not that. Sorry, 583 first, please. Page 583. This is in the section, but don't please turn back to it for reading speed, starting on 579 that Mr. Westmoreland Smith took you through, where he makes a point. Look how extensive the hearing process was, and he takes you all through all the information gathering exercises that EXA took. So I make this simple point in response to that. I can make this point about almost any stage of that, but let's make it with respect to 1.451. He emphasises the following requests for further information and comments under Rule 17 were issued on. Now, as was clarified, they're not requests for information about our issue. They're requests for information about they're just requests or related to it in any way. They're just requests for information about matters which might help the inquiry. And of course, in general, that's admirable and it's perfectly plain. The examining authority had a lot on its plate and did a very thorough job. But think about it in the context of our issue. The request for further information could not be informed by, the examining authority could not be alerted to the need for information on certain topics that it might otherwise have been alerted to because the landowners in question are not coming forwards. And by the same token, they can't answer the requests. So it doesn't answer the problem. And basically the same sort of point can be made about every other stage that Mr. Westmoreland Smith takes you to. That's point one. Point two, if we just turn up page, briefly turn up 599, just get the heading. My learned friend, both I think, and certainly Mr. Westmoreland Smith, make much of the point that 39 objections are outstanding at the time of the decision. You can see why on the face of it. But one does need to see what the reality of that is. So I've taken you to 599 because it's a heading, outstanding objections, and there are indeed 39 objections they go through. Can we please now turn to page 602? I'm not saying this is true of all of them, but it's true of a lot of them. 602, number 8, Ashton's legal for Natasha Mann. Status summary. Documents have been issued to the interested parties' legal advisors for signature. Over the page. 9, status summary, same point. 10, status summary, same point. 11, status summary, same point. 60.
Does that mean that they've got heads of agreement and they haven't signed on that?
I don't know exactly, my lady, but we do know that we're told that 80% of affected landowners have got heads of terms signed. So
that might
a lot of them do.
If they are people who signed heads of terms, that they've maintained their objections.
Sure, because the heads of terms, as some of these people would know, right? I haven't said they're legally binding.
No.
But critically, effectively, the objection's in limbo. They're close to an agreement. Now, the agreement, for reasons we don't know, the agreements are not signed within the kind of short period which we saw was envisaged in the heads of terms. And I don't know why that was. It may be that everyone thought, oh, we've got heads of terms. I don't know. But the reality of these so-called objections is they're semi-compromised. They're not being pursued. And why is that? Heads of terms. And that enables me to make 2 points. It's not, first of all, sorry, Malay, I can see.
I'm just thinking, I mean, how can they be semi-compromised? The objection's been put in, it hasn't been withdrawn, therefore it's there before the examining authority.
Sure.
And
but
it's there to be considered on the
It's there to be considered. But what it's not being is pursued, advanced, developed. It's not an active objection. And that's how it's treated. If you look at how each of these is treated, that's the nature, they say nothing about it. So in reality, the heads of terms are governing all of these objections. In practice, that's the practical impact of matters, they're not being pursued. And I think, those are the only 2 factual points. Can I then come back finally to the what I say anyway is the main issue of principle? which is the legal issue. Let's take first, there are two cases relied upon against me, so I take Taylor relatively quickly. Sorry. Taylor's at tab 8. If we go straight to the critical bit, really, 186 and 187 in the bundle, 629 to 630 report. And my submission is Taylor doesn't get you anywhere, doesn't take us anywhere. Why is that? Well, two of the reasons were highlighted by my Lord Justice Dingemans in argument with Mr. Westman, discussion, debate with Mr. Westman and Smith. So first of all, and most importantly, this issue is not being decided in Taylor. Our issue, is this kind of contract lawful or not, in accordance with public policy? The court doesn't decide that. Secondly, also I think highlighted on part of my Lord, page 186, I think you've probably got the reference, but sort of a quarter of the way down the page, just beyond, the objection is recorded and the recited the above facts, and that the line of the proposed railway will pass through the property of the said Sir Charles Taylor in such a manner as to intersect and seriously damage the same. He's accordingly intimated the company his intention to oppose the said bill. So his objection is absolutely based on damage to his land, not any wider point. So this case is perfectly capable of being brought within. I mean, probably was a legitimate case. But thirdly, one final point on this. I do ask you to remember, this case is 150 years old. And that's not just to make the point that the law has moved on in 150 years in public law in particular, though that is true. There's a slightly more analytic point. This case long predates planning control, development consent. And certainly as I understand it, the primary purpose of private bills of this kind was to authorise compulsory purchase. So it's a straight compulsory purchase case. Now, okay, one can see that in the course of considering whether to authorise such bills, Parliament is going to need to think about such matters as what's the best place for the railway line to go and so forth. But it's a million miles away from the present statutory scheme. And the idea that if I'm otherwise right on the Fulham case, this case takes us any further is, in my submission, not sustainable. So the heart of it is Fulham. As to Fulham and the wider point of principle, you've obviously got my submissions. Can I make two general points and then come to back briefly to the authority itself? General point one, probably the most important one. My lady correctly encapsulates what I hope is the submission I have put, which is the real vice of this kind of agreement, is that it catches the person who, alongside having a property right, perhaps a pretty minor property right, has an in-principle objection, much wider level of objection, which has got nothing to do with their property right. Might be marsh harriers, might be concerned about the character of the area, whatever. It might or might not be an issue on their land. That may not be the most important fact. Why should their ability to compromise their property right, their narrow property right, be affected by the fact that sorry, it's the other way around. Why should their ability to pursue that wider, in principle, public interest objection be affected by the possession of that property right?
Well, I think Mr. Philpott's answer to that is because you're free to contract on whatever.
Well, I was going to say, so I follow that. So to come at it then the other way, how can it be in the public interest that they be required to withdraw that objection in circumstances where it's unrelated to the property right and by no means necessary to the perfectly proper purposes of the compulsory purchase regime, amongst which, as my learned friends rightly say, one object is to do things by agreement if possible. But there is no necessity to secure that objective with getting voluntary agreement where possible, minimising the use of compulsory powers, to contract those people out of the right they would or the ability they would otherwise have to object. and the public interest is therefore damaged and not advanced by doing so. In a sense, that's a harsh submission. Before I come back to the authority, the other point I just want to pick up on is Mr. Westmoreland Smith said, right at the outset of his submissions, that this is all very different because planning is an administrative decision-making process. Remember, he took you to Bushel. Well, first of all, as a matter of principle, can't see why that makes any difference. I mean, query what's administrative and what's judicial and all the rest of it. I'm not sure my Lord Justice Dingemans will probably know better whether an inquiry is a judicial or an administrative or a quasi-judicial function. I can't remember. But why does it matter? It's a decision taken in the public interest, as we know from even without Tashka, it ought to be, one would expect the public interest on an important matter will be taken on the basis of the fullest possible information. And the environmental regime that we're dealing with rather reinforces that. So how could it be in the public interest to produce a different result? The other point I can make about this, I'll pick up the passage in a minute, is of course, in principle, we know these considerations apply because that's how it's approached in Fulham Football Club. The Court of Appeal doesn't say it's planning, it's only administrative, therefore don't worry about it. Rather, it identifies the public interest that balances it, and so forth. We don't. So that submission is just, with respect, wrong. Come back, final part of my submissions, 35 minutes, get there in 40. Tab 11, as I'm sure you know by now.
I don't remember you saying 40.
I don't think I said anything actually, but I was aiming for 30. But
Oh, I see.
Self-imposed discipline.
Page 3, just goes please straight to page 333.
333.
333, which is where the really important bit starts. So just kind of a couple of points as we go through it. So top of the page. I mean, these are all to a large degree points I've made, but I just want to emphasise again what the plaintiffs are saying. What I say must have loomed large in the is that Vincenzo said it. Sorry, the Fulham said it was seeking to act in the best interest of the club, which means it's commercial interests. And actually, if you think about it, that's why this case is relatively simple, because an essentially commercial organisation won't have a side interest in Marsh Harriers or the character and appearance of the area. So it's relatively easy to say for a commercial organisation, well, you pursue your planning objections with a commercial aim, it's legitimate, not because you have an in-principle position on it.
Might be thought to be slightly underselling the importance of football clubs.
Well, they pursue their aims. They pursue their aims as a football club, but they don't. And I'm not an expert on, or even a novice on company law, so I need to be a little bit careful. But they don't have, as a private individual has, a range of interests in, as it were, general. They're not free to pick and choose matters in the public interest. They act according to their articles of association. And what this organisation said it was doing was seeking to act in the best interest of the club. And it's perfectly plain because you see it later on. The court understood that to mean, on the facts of this case at least, the commercial interest. Second point. I mean, I think I've accepted that. Well, no, sorry. The key test is the one at the in that paragraph at the bottom of the page. Is there a public interest to balance the potential harm to the process? And that's the only test. And then applying that here, they say, well, there's a, and again, they come back to this point about commercial men. But lastly, and then importantly, in the way the argument went this morning in particular, we come back to that other final paragraph, 334, some debate about the way this all works. So it's the paragraph beginning, the court will consider the facts of each case. Obviously a point I emphasise for reasons you know. Then we've got the whereas here. So in a sense the issue is becoming, well, is that a comment about the facts of the case? Is that an observation about the facts of the case or a wider principle? That's the issue. But in my submission, as my lord put it, it's a contextual but whereas here. It's focusing on the facts of the case. And a critical clue is also further on in the sentence, because what it goes on to say is, has been entered into between parties at arm's length and one party agrees in return for a very substantial payment. Now, the reference to a very substantial payment, not just a payment, but a very substantial payment, is plainly a comment on the facts of that case. So if this is a point of principle, it's a very odd way of stating a principle, that this principle applies because the payment is very substantial. You'd think, if anything, in most cases, it would be the other way round. In other words, the more substantial the payment, the more questionable is the conduct. I mean, that may be going too far, but certainly it doesn't make it less questionable. Whereas if you think about it as a comment on the facts of a particular case, it's actually readily explicable, because it goes back to the point that I've made. You've got commercial persons, or a commercial body. They've made a bargain. They've been paid pretty handsomely for the bargain. Why should they be able to pull out of it? As a comment on the fact, it makes sense. As a comment, as a way of explaining the principle, it makes no sense at all. And, you know, that aside, standing back from this, it couldn't be clearer. The court will consider the facts of this case. Then it tells you what the facts are. And it says again, on the facts of this case, the covenanters, the particular complainants here, cannot rely on any rule of public policy. Those are comments about the facts. The statement of principle is 2 paragraphs earlier. My lords, my lady. Oh, I'm being, sorry. I thought I'd... I'm reminded, yes, sorry, I'm reminded, I haven't said anything at all about section, about the Senior Courts Act, highly likely. Can I just, I'm not going to make any detailed submissions.
No, of course.
Before we get to that,
Hold on. Can I turn my back?
you're going to answer the question I asked yesterday as to what legal advice was given to landowners.
Senior Courts Act, highly likely. First of all, it's not, in my submission, easy to see how this makes a difference in this case. How this adds anything, I should say, in this case. The reason for that is, to a large extent, this issue is brought in the submissions, in the stages that I've already made. Complaint is made to the Secretary of State. Does he deal with it adequately? If he deals with it adequately, then no error of law. If he doesn't deal with it adequately, that's got a lot to do with at least the possibility that it could have made a difference. And I've shown you what the minister was advised by their officials in that ministerial submission, which at least seems to imply it could have made a difference. Secondly, and I don't know if this is a point that matters at all actually, so I might just make it. Carver BN, I accept the principle. Well, so tab 22, authorities tab 22. So 796 of the bundle is a straight to. Couple of points. Burden of proof on the defendant. I know this is accepted. Burden of proof on the defendant. Pretty important. They need to bring forward evidence to satisfy you the decision-making process would have been the same. And with my respect to the Commission, I haven't done that. Sets a high hurdle. Only 2. Obviously, rely on that. Roman 3, I've actually got a bit of a problem with. I don't think it's approved at the court to this court's level. I mean, I know what the judge, Mr. Justice Kirkland, said it was getting at, but the civil and criminal standards are about the proof of a past fact, not about what would have happened in the future. So one knows what he's getting at by saying it's a difference between somewhere between civil and criminal, but respectfully suggest it's not quite right. But in any event, the other point that I just want you to have in mind, if we then go on in the principle, I'm not ignoring the rest of it, but I'm taking it quickly.
Should I know the answer to the question I was about to ask?
I don't know if I should know the answer to that question.
No, well, then I perhaps ought to ask it. Has Cover Bien been endorsed at a higher level.
Whether you should know, I don't know. That was a question you asked me, but I don't know. And whether or not I should, I don't know. We can probably try and. I mean, for what it's worth, subject to the, and it's rather a technical lawyer's point about criminal and civil standard that I've just made. I mean, I accept these principles. I'm not inviting you to depart from it. I think
It
it's.
says highly likely, and
Yeah.
highly likely means highly likely.
Yeah, I mean, that's
so-
fine. So Roman 2 is better than Roman 3. Roman 3 is a bit of a gloss. Can I just come on to Roman 9 and what follows? But I think I can make the point by Roman. Sorry, it's not Roman 9, it's Roman 11. I'm very bad at reading Roman 9. Page 798.
There is Goring on Thames.
It's referring to Goring on Thames, yeah.
Yes.
But the point that's made, which in my submission must be correct, importantly, the court must not cast itself in the wrong decision making. And that's critical, in my respectful position here.
Yes,
And this is a very wide-ranging
I think
decision.
that's what I said in that case.
Oh, is that your? I didn't pick. I overlooked the rule judgment. In that case, I particularly endorse it. But
I think I wrote the lead judgment.
I'm sure you did. Well, there we are. I mean, anyway, it's an important. Whoever, you know, I don't sound sycophantic. It's an important point. And it's an important point here, because what you know, this is a very multifactorial decision making.
Yes.
And the only question is, could the outcome have been different? Plainly it could. And I know I've shown you what the examining authority said about it being finely balanced. Okay, the Secretary of State doesn't endorse that, but he doesn't resolve from it. Mr. Philpott says he applies the IROPI test, but that doesn't help him at all, because that's actually just setting a higher hurdle. He's not saying I applied the IROPI test and I came down clearly on one side of the line. He's just saying I applied the IROPI test and I decided it one way or another. He's not saying I didn't almost decide it the other way. So that doesn't help at all. My lords and my lady, I think, unless I get another tug, those are my submissions. Oh,
If it helps, we understand that Savabian has not been considered by the court, it has not been endorsed. as far
All
as
right,
I'm
well,
aware.
thank you very much.
I'm standing because you haven't told me that there are no further questions.
Absolutely.
I'm taking that.
Thank you very much, Mr. Bury. Thank you. Well, thank you all very much. All counsel and those with them who have contributed to very well crafted arguments in front of us. You've given us plenty to think about. We propose to do that, and thus the judgments in this appeal will be reserved. In due time, a draft of our judgments will be issued for typographical and minor factual corrections only. At that stage, parties should endeavour to agree a draft order. If there is disagreement about the order, then submissions relating to such disagreement should be made at that stage, please. The draft judgment will, as is normal these days, be subject to a strict embargo, which must be heeded, and if it is not heeded, there may very well be significant consequences. Thus, the procedure on for hand down will be as is now normal. Thank you.